to allow that, to accept the idea that the House can bring an impeachment here that is not adequately supported, that has not been investigated, that has not got a record to support it, and to turn this body into the investigatory body would permanently alter the relationship between the House and the Senate in impeachment proceedings. It's not the role of the Senate to have to do the House's job for them. It's not the role of the Senate to be doing an investigation and to be doing discovery in a matter like the impeachment of a President of the United States. If the House has not done the investigation and cannot support its case, it's not the time once it arrives here to start doing all that work. That's something that's the House's role. So, this is something that is important for this institution, I believe, not to allow the House to turn it into a situation where this body would have to be doing the House's work for it. If there is not evidence to support the case, if they haven't done their investigation, then they're not going to be able to support their case. Again, what's at issue here, and I think it's important to recall on the issue of this amendment, it's not whether the Senate, whether this body will be considering whether there should be witnesses or not, but when that should be considered. And there is no reason not to take the approach that was done in the Clinton impeachment. 100 senators agreed then that it made sense to hear from both sides before making a determination on that. To hear from both sides, to see what sort of case the House could present and the President's defense. And that makes sense. In every trial system, there is a mechanism for determining whether the parties have actually presented a triable issue, whether there is really some there that requires the further proceedings. And this body should take that common sense approach and hear what it is that the House managers have to say. Why are they afraid to present their case? They had weeks in a process that they controlled to compile their record, and they should be able to make that presentation now. And the one point that I will close on, we've heard Manager Schiff say several times that we have to have a fair process here, and I was struck by it that at one point he said if you allow only one side to present evidence, the outcome will be predetermined. The outcome will be predetermined. That's exactly what happened in the House. Let's recall that the process they had in the House was one-sided. They locked the President and his lawyers out. There was no due process for the President. They started with secret hearings in the basement. The President couldn't be present by his counsel. He couldn't present evidence. He couldn't cross-examine witnesses. And then there was a second round in public, where again they locked the President out. And we've heard, they just said that the President had an opportunity to participate. In the third round of hearings that they held before the Judiciary Committee, after one hearing on December 4th, Speaker Pelosi, on the morning of December 5th, went out and announced the conclusion of the Judiciary Committee proceedings. She announced that she was directing Chairman Nadler to draft articles of impeachment. That was before the day that they had set for the President even to tell them what rights he wanted to have and to exercise in their proceedings. It was all already predetermined. The outcome had been predetermined. The Judiciary Committee had already decided it was not going to have any fact hearings. There was no process for the President. He was never allowed to participate. So when Chairman Schiff says here that if you only allow one side to present evidence, that predetermines the outcome, that's what they did in the House, because they had a predetermined outcome there, because it was all one-sided. And for him to lecture this body now on what a fair process would be takes some gall. A fair process would be when you come to the day of trial, be ready to start the trial and present your case, not ask for more discovery. The President is ready to proceed, and the House managers should be ready to proceed, and this amendment should be rejected. Thank you.
Counsel, the House managers have 8 minutes remaining.
The House is certainly not asking the Senate to do the House's job. We're asking the Senate to do its job, to hold a trial. Have you ever heard of a trial that doesn't have evidence, that doesn't have witnesses? That's what this amendment is all about. Just a moment about the subpoenas. President Trump, refused to provide any information to the House, ordered all of his people to stonewall us. Now, it's been suggested that we should spend 2 or 3 years litigating that question. I was a young law student, actually, working on the Nixon impeachment many years ago. And I remember the day that the Supreme Court issued its unanimous decision that the president had to release the tapes. I think U.S. v. Nixon still governs the president. The House and the Senate should not be required to litigate U.S. v. Nixon back to the Supreme Court and down again for it to be good law. It is good law. The president has not complied with those requirements to the detriment of the truth. This isn't about helping the House. This isn't about helping the Senate. This is about getting to the truth and making sure that impartial justice is done and that the American people are satisfied that a fair trial has been held. I would yield now to my colleague, Mr. Schiff.
Mr. Philbin says that the House is not ready to present its case. Of course, that's not something you heard from any of the managers. We are ready. The House calls John Bolton. The House calls John Bolton. The House calls Mick Mulvaney. Let's get this trial started, shall we? We are ready to present our case. We are ready to call our witnesses. The question is, will you let us? That is the question before us. Now, Mr. Philbin says, well, if I showed up in court and said I wasn't ready, the judge would throw me out of the court. Of course, we're not saying we're not ready. But you know what would happen if Mr. Philbin went into a court and the judge said, I've made a deal with the defendant. I'm not going to let the prosecutor call any witnesses. I'm not going to let the prosecutor present any documents. You know who'd get thrown out of the court? The judge. The judge would be taken out in handcuffs. So let's step out of this body for a moment and imagine what a real trial would look like. It would begin with the government receiving documents, being able to introduce documents, being able to call witnesses. This trial should be no different. Now, Mr. Philbin makes reference to the Cipollone letter on October 18th, which followed a Cipollone 8-page letter on October 8th saying, we're not going to do anything you ask. Part law, part diatribe, mostly diatribe. You should read it. It's a letter basically that says what the president said on that TV screen, which is, we're going to fight all subpoenas. The doctrine of absolute immunity that counsel refers to has, yes, it has been invoked or at least attempted by presidents of both parties and rejected uniformly by the courts, including in the most recent decision involving Don McGahn, the president's former White House counsel, where the court said that would make him a king. He's no king. And this trial has determined that he shall not become a king, accountable to no one, answerable to no one. And what's more, this idea of absolute immunity, this fever dream of presidents of both parties, it has no application to documents. Again, this amendment is on documents. There's no absolute immunity from providing documents. And as Representative Lofgren illustrated, when this case has gone to the Supreme Court, in the Nixon case, the court held that the interest in confidentiality in an impeachment proceeding must give way to the interests of the truth and the Senate and the American people. You cannot invoke privilege to protect wrongdoing. You cannot invoke privilege to protect evidence of a constitutional crime like we have here. And finally, with respect to those secret hearings that counsel keeps referring to, those secret depositions in the House were so secret that only 100 members of Congress were able to be there and participate. Only 100. That's how secret that chamber was. Imagine that in the grand jury proceedings in the Clinton investigation or in the Jaworski, the Nixon investigation, imagine inviting 50 or 100 members of Congress to sit in on those. Imagine, as the president would like here, apparently the president insisting on having his lawyer in the grand jury because there was a case being investigated against him. Now, we had no grand jury here. Why is that? Why did we have no grand jury here? Why was there no special prosecutor here? Because the Justice Department said they're not going to look into this. Bill Barr's Justice Department said there's nothing to see here. If it were up to that Justice Department, you wouldn't know anything about this. That's why there was no grand jury. That's why we in the House had to do the investigative work ourselves. And yes, just like in the Nixon case, just like in the Clinton case, we used depositions. And you know what deposition rules we used? Those terribly unfair deposition rules we used? They were written by the Republicans. We used the same rules that the GOP House members used. That's how terribly unfair they were. My gosh, they used our rules. How dare they? How dare they? And now why did we do depositions? Because we didn't want one witness to hear what another witness was saying so they could either tailor their stories or know that they just had to admit so much and no more. It's how every credible investigation works. And this, the counsel can repeat all they like that the president didn't have a chance to participate, didn't have a chance to have counsel present in the Judiciary Committee or to offer evidence. They can say as much as they like. It doesn't make it any more true when they make the same false representation time and time again. It just makes it that much more deliberate and onerous. The president could have presented evidence in the Judiciary Committee. He chose not to. And there's a reason for that. There's a reason why the witnesses they've talked about aren't material witnesses. They don't go to the question of whether the president withheld the aid for this corrupt purpose. They don't go to any of that because they have no witnesses to absolve the president on the facts. You should want to see these documents. You should want to see them. You should want to know what these private emails and text messages have to say. If you're going to make a decision about the president's guilt or innocence, if you're going to make a decision about whether he should be removed from office, you should want to see what these documents say. Now, if you don't care, if you've made up your mind that he's the president of my party or for whatever reason, I'm not interested. And what's more, I don't really want the country to see this. Well, that's a wholly different matter. But that's not what your oath requires. It's not what your oath requires. The oath requires you to do impartial justice, which means to see the evidence. To see the evidence. That's all we're asking. Just don't blind yourself to the evidence. It's just, I yield back.
Thank you. The majority leader is recognized.
I send a motion to the desk to table the amendment and ask for the ayes and nays.
The question is on the motion to table. Is there sufficient second? There is. The clerk will call the roll.
Mr. Alexander.
Aye.
Ms. Baldwin.
No.
Mr. Barrasso.
Aye.
Mr. Bennett.
No.
Mrs. Blackburn.
Aye.
Mr. Blumenthal.
No.
Mr. Blunt.
Aye.
Mr. Booker.
No.
Mr. Bozeman.
Aye.
Mr. Braun.
Aye.
Mr. Brown. Mr. Burr.
Aye.
Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth, Mr. Durbin, Mr. Inze, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Lankford, Mr. Leahy, Mr. Lee, Mrs. Loeffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
Are there any senators in the chamber wishing to vote or change his or her vote? If not, the yeas are 53, the nays are 47. The amendment is tabled. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain documents and records from the State Department, and I ask that it be read.
The clerk will read the amendment.
The senator from New York, Mr. Schumer, proposes an amendment, number 1285. At the appropriate place in the resolving clause, insert the following section. Notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedures and Practice in the Senate when sitting in impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the Secretary of Senate commanding him to produce, for the time period from January 1, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the Department of State, referring or relating to A, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21 and July 25, 2019 telephone calls, as well as the President's September 25, 2019 meeting with the President of Ukraine in New York. B, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF, including but not limited to all communications with the White House, Department of Defense, and the Office of Management and Budget, as well as the Ukrainian government's knowledge prior to August 28, 2019, of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance to Ukraine, including all meetings, calls, or other engagements with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine. C, all documents, communications, notes, and other records created or received by Secretary Michael R. Pompeo, Counselor T. Ulrich Breckbull, former Special Representative for Ukraine Negotiations Ambassador Kurt Volker, Deputy Assistant Secretary George Kent, then United States Embassy in Ukraine Chargé d'Affaires William B. Taylor, and Ambassador to the European Union Gordon Sondland, and other State Department officials relating to efforts to 1, solicit, request, demand, induce, persuade, or coerce Ukraine to conduct or announce investigations, 2, schedule, cancel, or withhold a White House meeting for Ukraine's president, or 3, hold and then release military and other security assistance to Ukraine. D, any meetings or proposed meetings at or involving the White House that relate to Ukraine, including but not limited to 1, President Zelensky's inauguration on May 20, 2019 in Kiev, Ukraine, including but not limited to President Trump's decision not to attend, to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and the subsequent decision about the composition of the delegation of the United States. 2, a meeting at the White House on or around May 23, 2019, involving, among others, President Trump, then Special Representative for Ukraine Negotiations Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3, meetings at the White House on or about July 10, 2019, involving Ukrainian officials Andriy Yermak and Alexander Danieluk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, and Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and a subsequent meeting in the wardroom. 4, a meeting at the White House on or around August 30, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper. 5, a planned meeting, later canceled in Warsaw, Poland, on or around September 1, 2019, between President Trump and President Zelensky, and subsequently attended by Vice President Pence. And 6, a meeting at the White House on or around September 11, 2019, involving President Trump, Vice President Pence, and Mr. Mulvaney concerning the lifting of the hold on security assistance for Ukraine. E, all communications, including but not limited to WhatsApp or text messages on private devices between current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, Ambassador Sondland, Ambassador Taylor, and Deputy Assistant Secretary Kent, and the following: President Zelensky, Andriy Yermak, or individuals or entities associated with or acting in any capacity as a representative, agent, or proxy for President Zelensky before and after his election. F, all records specifically identified by witnesses in the House of Representatives impeachment inquiry that memorialize key events or concerns, and any records reflecting an official response thereto, including but not limited to: 1, on August 29, 2019 cable sent by Ambassador Taylor to Secretary Pompeo; 2, an August 16, 2019 memorandum to file written by Deputy Assistant Secretary Kent; and 3, a September 15, 2019 memorandum to file written by Deputy Assistant Secretary Kent. G, all meetings or calls, including but not limited to all requests for or records of meetings or telephone calls, scheduling items, calendar entries, State Department visitor records, and email or text messages using personal or work-related devices between or among: 1, current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, and Ambassador Sondland; and 2, Rudolph W. Giuliani, Victoria Tensing, or Joseph DeGeneva; and H, the curtailment or recall of former United States Ambassador to Ukraine, Marie Masha Yovanovitch, from the United States Embassy in Kiev, including credible threat reports against her and any protective security measures taken in response. And 2, the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice.
The Majority Leader is recognized.
I now ask for a brief 10-minute recess before the parties are recognized to debate the Schumer amendment. At the end of the debate time, I'll again move to table the amendment as the timing of these votes are specified in the underlying resolution. So I ask consent that the Senate stand in recess subject to the call of the chair.
Without objection, the Senate is in recess.
Her name was there.
Senate will come to order. The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent?
Proponent, Mr. Chief Justice.
Thank you. And Mr. Cipollone?
Opponent.
Okay. Mr. Schiff, you have an hour, and we'll be able to reserve time for rebuttal.
Chief Justice Roberts, Senators, Counsel for the White House. I am Val Demings from the state of Florida. The House managers strongly support the amendment to issue subpoena for documents to the State Department. As we explain, the first article of impeachment charges the president with using the power of his office to solicit and pressure Ukraine to announce investigations that everyone in this chamber knows to be bogus. The president didn't even care if an investigation was actually conducted, just that it was announced. Why? Because this was for his own personal and political benefit. The first article further charges that the president did so with corrupt motives, and that his use of power for personal gain harmed the national security of the United States. As the second article of impeachment charges, the president sought to conceal evidence of this conduct. He did so by ordering his entire administration, every office, every agency, every official to defy every subpoena served in the House impeachment inquiry. No president in history has ever done anything like this. Many presidents have expressly acknowledged that they couldn't do anything like this. President Trump did not take these extreme steps to hide evidence of his innocence or to protect the institution of the presidency. As a career law enforcement officer, I have never seen anyone take such extreme steps to hide evidence allegedly proving his innocence. And I do not find that here today. The president is engaged in this cover-up because he is guilty, and he knows it. And he knows that the evidence he is concealing will only further demonstrate his culpability. Notwithstanding this effort to stonewall our inquiry, the House amassed powerful evidence of the president's